2024, how yes. Continued promise.
The promise is broken by 24. At least from the fact the promise is broken. Now, it is that the promise to marry is not performed subsequent to July. That is the
Marriage is not performed, the promise is not performed.
promise is breached by 24. He has blocked that. Post July 2024, not since the marriage is not performed. Virtually not a negative specific performance.
But as on that date, Lord, where this relationship occurred, such a law was not.
Will answer, yes.
So not a law at all, except for a couple of declarations where not in case of a minor. It was not a.
Sometimes Rolling Stones also happens. It gathers mass.
Yes.
Okay, yes.
84.
Other namge avarge matter. Yes, list
Please.
on 21st.
Please. Oblige.
84 minutes.
With this we have to hear it.
Minutes. This no. I'll just point out what had happened. Minutes. I had filed a writ minutes on the GM side. Not saying that the surface action should not be taken. Court said, though you are neither a borrower nor a guarantor, show me your bona fides. You deposit X amount of money. And thereafter, minutes I deposited. Your lordship passed an order that the writ may not be maintainable. So that was the point where I withdrew the writ. And I said, minutes I will avail.
It's a very old proceeding.
Correct, minutes. Now the deposit is lying before this honorable court. The judicial deposit is lying before this honorable court. And I'm not on the relief side.
Again, what have you sought here?
So what I'm seeking, there was a deposit made by me in this writ petition, Minutes. Deed is for
Withdrawal of the deposit.
I'm only for withdrawing that. Nothing on the merits. Nothing.
Respondent. Here, man. Yaru ilvala?
Let it be passed over minutes. I'll try and intimate them. The
Will speak.
banker was there.
Yaru?
The banker was appearing minutes.
Let it be passed over.
Please.
Pass over, yes.
85.
If my lord should kindly have page number 25, my lord. Paragraph number 14 of the complaint.
Deposit, okay.
The accused number 2, my lord, is a government doctor. Both, my lord, 1 and 2 are government doctors. Mother and child hospital. Mission and
Mother and child hospital.
ಹೌದು.
ಆತರ ಇದೆಯಾ?
ಅದೇ ಎಲ್ಲಾ ಕಡೆನೂ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ, ಹೆಸರೇ ಮದರ್ ಅಂಡ್
ಹೌದು,
ಚೈಲ್ಡ್
ಹೌದು.
ಹಾಸ್ಪಿಟಲ್. ಓಕೆ.
ಮದರ್ ಅಂಡ್ ಚೈಲ್ಡ್ ಹಾಸ್ಪಿಟಲ್ ಅಂತ ಎಲ್ಲಾ ಕಡೆನೂ ಮಾಡಿದೆ. ಎಲ್ಲಾ ಡಿಸ್ಟ್ರಿಕ್ಟ್ಸ್ ನಲ್ಲೂ
ಹಾ ಸರಿ, ಏನಿದೆ
ತಾಯಿ ಮಕ್ಕಳು
ಪ್ರಾಬ್ಲಮ್ ಏನಾಗಿದೆ?
ಅಲ್ಲಿ ಆ ಮೆಷಿನ್ ಇತ್ತಂತೆ. ಇದ್ದಿದ್ದಕ್ಕೆ ನೀವ್ಯಾಕೆ ತಗೊಬಂದು ಇಟ್ಕೊಂಡ್ರಿ ಅಂತ.
ಸ್ಕ್ಯಾನಿಂಗ್ ಮೆಷಿನ್ ಅಷ್ಟೇನಾ?
That's all. In fact, the complaint, my lord, speaks that if there was, my lord, an allegation that the complaint machine was used or whatsoever, my lord, I agree. Only one.
In every case you put it so that there's nothing.
Fortunately, my lord, I get such cases on briefing
Hello.
that, my lord,
Not a case for interim order at all.
my lords may not say it so lightly. No sanction, my lord, no sanction, and compulsory citing of the witnesses under the names of the witnesses are said. But my lord, the cherry on the cake that who has spoken to this so-called violation, they are not made the witnesses. The witnesses' names are cited under the FIR, under the complaint.
What flavor?
The cherry itself.
Alla cake.
A clear case of, my lord. In fact, my lord, there are a lot of irregularities in, my lord, implementing this
There's
act.
a flavor called death by chocolate.
Death by chocolate.
ಅದೇ
Death by
ಸೊ
chocolate.
ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. No interim order. Yes.
I am the government doctor.
Correct.
No sanction is taken.
Yes, sir.
No sanction.
Like, who did not have? She visited the hospital. Uh,
No,
That's all right. Who has recommended scanning?
absolutely there is no content to that effect.
Where is the document to show that she has recommended?
Absolutely zero content on that. It's only, my lord, a passing allegation.
ಅವ್ರಿಗೆ ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
Alla, Jagdish are correct. But he's clogged with so much of work. He might not have read the entire file. If my lord said, in fact, complaint says it.
You're telling about yourself or him?
My friend, my lord.
Friend. Okay.
My friend.
ಅಲ್ಲಿ ನಿಮಗೂ ಕೆಲಸ ಜಾಸ್ತಿ ಇರುತ್ತೆ.
So I'm honored, my lord. That statement, if there is some statement, my lord, they have to be cited as a witness. My lord, kindly see who is being cited as a witness.
What are
Page
you
number
giving
30. He is not even a witness.
But ಏನಿದೆ? ಈಗ now you have initiated proceedings against her for offense under PCPNDT, including IPC, na?
Illa. What he said, my lord, under the complaint,
23 of PCPNDT.
yes.
ಅದಕ್ಕೆ sanction.
Sanction illa. Cognizance ತಗೊಂಬಿಟ್ಟಿದ್ದಾರೆ already.
Why? Why is not discharge? What was she doing then?
No. What is this?
Which is mother and child is a private hospital, sir.
No, my lord, government
hospital.
It is run by government. Kanakapura mother and child hospitals are there everywhere. I have produced my appointment order also. If your lordship would
Page.
kindly have page number 33. Item number 5.
ಸಾರ್ವಜನಿಕ ಆಸ್ಪತ್ರೆ ಕನಕಪುರ ಸಾರ್ವಜನಿಕ ಆಸ್ಪತ್ರೆ.
Howdo? That those hospitals, sir, my lord, are titled as mother and child hospitals at every district level.
Where
It's
do you
run
get-
by government.
Where do you get that?
If your lordships could kindly see in the complaint itself, my lord.
No, anyway, there is your transfer order is set aside by KIT, page 53.
My transfer order is set aside. I was working here. Pursuant to this case, I was transferred. KIT says that transfer order is incorrect, illegal. I am not, my lord, banking upon that. KIT, my lord, prima facie felt that I was not guilty. That machine was kept, my lord, government. ಒಂದು ಹಾಸ್ಪಿಟಲ್ ಇಂದ ತಗೊಂಬಂದು ಫ್ರಮ್ ದ ಗವರ್ಮೆಂಟ್ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆ ಕನಕಪುರದಿಂದ ತಗೊಂಬಂದು ಇಲ್ಲಿ ತಾಯಿ ಮತ್ತು ಮಕ್ಕಳ ಆಸ್ಪತ್ರೆನಲ್ಲಿ ಇಟ್ಟಿದ್ದಾರೆ.
Where is the document to show that this particular mission was directed to be shifted to her hospital? There is no document.
That's not my case. That's not my look after. You come and dump so many things in the hospital, and how am I held responsible for that?
You made.
Tomorrow you will keep a ballistic missile in the hospital. How can I question it?
You. Illustration.
Kindly see, my lord.
ಅಲ್ಲ, why so extreme illustration, sir? Scanning machine go ballistic mission. Why do you go nuclear?
Government, my lord, keeps dumps, my lord.
That's all right. Why do you go nuclear?
Because I am failing.
Sir, illustration ಮಧ್ಯದಲ್ಲಿ ಯಾವ್ದಾರು ಕೊಡಿ.
Such a formidable man, my lord.
They would not have kept this mission in this hospital.
Who has kept it?
The petitioner also has to play a role.
Who has kept it?
Petitioner, accused number 1 has kept it. Accused number 2, my lord, has used this mission.
Who has kept it? ಅವ್ರು ತಗೊಳ್ಳಿ. Accused number 1 is also a government servant. ಈಗ ಸ್ಯಾಂಕ್ಷನ್ ಇಲ್ಲ ಅಂದ್ರೆ ಅವ್ರಿಗೂ ಹೆಲ್ಪ್ ಆಗುತ್ತೆ.
Sanction illa. Seemingly there is
ಸ್ಯಾಂಕ್ಷನ್
no
ಇಲ್ಲ ಅಂತ
sanction.
ಗೊತ್ತು, ಅದು ಬೇಕಾಗಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಿರೋದು. No problem. You place it. When do you want? Well, take 1 week. Yes. Heard the learned senior counsel M.S. Shamsundar appearing for the petitioner. The learned additional SPP submits that he would secure the records and place it before the court. The allegation against the petitioner is the one punishable under section 23 of the PCPNDT. The crux of the allegation is that the scanning machine that was installed in the government hospital was directed to be operated without prior permission. The accused number 1 is said to have shifted the scanning machine and placed it in the hospital. And the petitioner is alleged to have issued certain prescriptions to conduct scanning in the government hospital. Barring this, there is no other allegation prima facie. Therefore, till the additional SPP would secure instructions and place it before the court, there shall be an interim order of stay, so and so, pay the petitioner.
So great,
ಯಾವ 20th?
so great.
ಈಗ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ತಗೊಂಬರ್ಬೇಡಿ ಅಮ್ಮ.
ಇಲ್ಲ, maybe he'll, my lord, he will tailgate this.
Sanction ಅದಕ್ಕೆ ಬರಲಿಲ್ಲ.
ಅಲ್ಲ, in fact, otherwise, my lord, section
ಇಲ್ಲ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 will walk away.
ಅಲ್ಲ, 20, there is one more sanction which is required, my lord. One is 197.
ಇದು
One more is, my lord,
28 I guess.
yes, 28. 15 days, my lord, notice
Act
of
alert.
intended action has to be given, even that is also not done. ಇಲ್ಲ, ಅದು ಶೋಕಾಸ್ ನೋಟಿಸ್, it is not intended action notice. ಅದು ಶೋಕಾಸ್ ನೋಟಿಸ್.
ಶೋಕಾಸ್ ಅಲ್ಲಿ ಇರುತ್ತೆ, ಇಲ್ಲದೆ ನಿಮಗೆ ಕ್ರಿಮಿನಲ್ ಮೊಕದ್ದಮೆ ಇಲ್ವಾ? ಮತ್ತೆ
ಇಲ್ಲ, ಅದ್ರಲ್ಲಿ ಇಲ್ಲ, intended action ಇಲ್ಲ.
ಇದ್ದೇ ಇರುತ್ತೆ, ಸೈಕ್ಲೋ ಸ್ಟೈಲ್ ಆರ್ಡರ್ಸ್ ಅದೆಲ್ಲ ಇರ್ಲೇಬೇಕು. ನೆಕ್ಸ್ಟ್
86,
Request for 17th or 18th, madam. Objections are filed like either on
CCIR 17th
17th or 18th.
ಹಾಕ್ಲಿ ಬಿಡಿ, ಅವತ್ತು ಮುಗ್ಸೋಣ.
ಅಲ್ಲ, objection ಹಾಕಿದೆ. It's already for
ಆಯ್ತು.
hearing already.
At the request of the learned counsel appearing
Madhukar Desh.
Madhukar Deshpande, list the matter on 17th.
Yes.
Yes.
87,
505 subclause 2 is involved.
Why did you speak all that?
It's, I have said that it is danger, Islam is a dangerous to the earth.
ಇಲ್ಲ ಓದ್ಬೇಡಿ, but why did you speak all that?
Yes, it's a speech. but
ಸುಮ್ಮನೆ ಇರಕ್ ಆಗದೇ ಇಲ್ಲ. You have to incite something somewhere.
Has not resulted with any communal.
That's is true. Other ಮೇಲೆ you get away. Again you go and write. Where was the necessity to speak all that?
Carelessness, that's.
Huh?
It's a carelessness.
What? I'm seeing day in and day out. ಬರೆಯಕ್ ಬರುತ್ತೆ ಅಂತ ಏನ್ ಬೇಕಾದ್ರೆ ಬರೆಯೋದು.
Matter is, now the investigation is completed. We have placed the investigation paper before the deputy commissioner for grant of sanction.
But how does it answer
Multiple
Javed
cases,
Hajam and
the multiple cases.
Shiva Prasad
against these
same
people
wall?
of- Multiple cases against these people of similar nature.
True. ಅದಕ್ಕೆ ಹೇಳಿದ್ದು, why all this?
It's a strongly worded.
I know it is.
But
It
he's
need
not
not,
a-
see, it need not result in violence or something. If it is capable of generating violence, that is enough.
But it's, the complaint is not a capitative audience. It's free to avoid the listening of the speech.
Get the paper, say, multiple complaints ಏನು? What multiple complaints? ಕೊಡಿ madam.
Not against this particular, accused number 1 has similar cases also in that.
Accused number 1 ಯಾರು? You are accused number 1?
Accused number 2 has the
2 has,
yes,
but 1 ಮೇಲೆ ಏನು?
same gang.
Gang? Gang.
Indicate.
Anyway, get the papers. I'll list it on 10th. You should ask him to encourage restraint. It's not correct. How long will you do all this?
Well, it's
On 10th we'll grant.
great.
Yes. 27B,
Your Lordship, 27B.
to hear the other side.
In this, Your Lordship.
Then
the co-accused-
parcel comes to you, is it, or what?
There's only consumption allegation that is made. Another thing is that the co-accused are all, it has been quashed against the co-accused.
How costly?
Coordinate bench has quashed. Coordinate bench is quashed against multiple.
Yeah, which is that, Cody? Well, you should go before the same bench. Co-accused, other, it should go before the same bench. Ah. Which is that, madam?
Lordship, it's filed, I have filed those orders under, page 729,
729?
volume 2 only,
all right.
729 page number.
Justice Hemant Chandra. Justice Hemant Chandra ಅವರು ಅಲ್ಲೇ ಹೋಗ್ಲಿ ಅವರು. The learned counsel for the petitioner submits that the co-accused, a coordinate bench in writ petition 7178 of 2024 has quashed the proceedings. In that light, registry is directed to place the matter before the same bench in the light of the circular ಅದೇನೋ ಇದೆ ಒಂದು ಅವೇ ನೋಡಿ ಇಲ್ಲಿ ಇದ್ರ ಮೇಲೆ ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ circular so and so.
Agreed.
Yes.
89,
For the petitioner.
Generally, this case, your
Huh?
lordship. Generally, your lordship has dismissed.
ಯಾವ್ದು?
Case ಮೇಲೆ.
Correct.
Subsequently coordinated.
ಯಾವ್ದು ಹೇಳಿ?
Indian NDPS. ಮೇಲೆ.
27B na. Anyway, coordinate which is allowed it. Should go there.
304B, 498.
Lethal combination.
My lords.
Lethal combinations. 498A, 304B.
Alla, totally 7 accusers, my lords.
Hmm.
Accused number 1 is husband. He is not before this court.
Parvailla.
Accused number 2 is, my lords,
Hmm.
mother-in-law. Accused number 3 is elder sister-in-law. Accused
Parvailla.
number 4 is younger sister-in-law.
When, what is the date of the crime?
Date of the crime is just 10/5/2024.
But investigation.
Allah, my lords, kindly.
No, sir.
Allah, please, my lord. I will,
No, sir.
2 minutes time, I will explain. My
Oh,
lords.
really, sir.
No, complaint itself, my lords, it narrates, my lords, both the deceased and the husband were residing in Bangalore right from the date of the
All
marriage.
right, we'll see.
No,
No problem.
ಮಹಾರಾಷ್ಟ್ರದಲ್ಲಿ ಇದಾರೆ, ಬಳ್ಳಾರಿ
Yeah.
ಕಲಬುರ್ಗಿಲಿ ಇದಾರೆ.
Bail ತಗೊಂಡಿಲ್ವಾ?
ತಗೊಂಡಿದೀವಿ ಸ್ವಾಮಿ.
ಸರಿ.
ಅಲ್ಲ, kindly, please, my lords, until then, I will make out.
Till what, sir? Bail ತಗೊಂಡಾಗಿದೆ.
2 minutes, my lords, I will explain the case, please. Kindly see page number 18, my lords.
Get the investigation papers. The learned HCGP is directed to secure the investigation papers and place it before the court. 11th in the fresh matters list.
Not even an iota of ingredient, my
11th in the, bail ತಗೊಂಡಿದ್ದೀರಾ ತಾನೆ?
bail ತಗೊಂಡಿದೀನಿ.
11th in the fresh matters list. Next.
90,
In the meantime, next. FOC, forest offense. Yes, sir.
In spite of there being a subsisting order, which is.
What order, sir?
Order passed by this honorable court at page number 64.
ನೋಡಿದ್ದೀರಾ?
I need time, I'll file my objection.
Oh, ಇದು 2009 order.
Yes, my
All
lord.
right, we'll see.
My lord, may I persuade my lord in so far as the
Okay.
registration of the FIR is concerned and consequent proceeding? Kindly appreciate at page number 66,
Hmm.
para number, after para number 6.
Hmm.
Respondent 2 is directed to consider the application of the petitioner for regularization
Hmm.
within a period of 6 months from the date of receipt of this order. It
Hmm.
is open for the petitioner to make fresh application for regularization of the earlier application is not found.
Hmm.
Till the application is considered and disposed of, the respondent shall not give effect to annexure H. I am in the circumstances where my protection is protected, my possession is protected by virtue of this order. It is
Hmm.
not the say of the respondents that
Let
the
him see and come.
the representation has been.
Land, my lord, even recently.
No, no, that is
That's
true.
it.
FOC will not straight away grant. Heard the learned senior counsel V. Shankar Narayan Rao appearing for the petitioner. Learned additional SPP is directed to accept notice, secure the papers, particularly with regard to the submission of the counsel for the senior counsel for the petitioner that he is protected in terms of page 64 on order, the number ಹಾಕ್ಬಿಡಿ madam. Yes, so and so, list on 12th.
My lord, till then a
No, sir.
limited protection, otherwise
No, no.
coercive action, FIR is registered. My lord, may
Let it
kindly
be.
see at page number 71.
Yes, sir,
Yep.
list on 12th in the fresh matters list. Yes, next.
92,
While it is in the custody of.
ಏನ್ DRT ಲಿ ಖಾಲಿ ಆಗಿದೆ ಎಲ್ಲ.
Clarity ಖಾಲಿ ಆಗಿಲ್ಲ, ಎಲ್ಲ
ಯಾವ ಇಷ್ಟು ಕೇರ್ಲೆಸ್ ಆದ್ರೆ DRT ಲಿ ಸಾಧ್ಯವೇ ಇಲ್ಲ. No, sir. You can't take the litigants for a ride like this.
But I appear for State Bank of India. I am a panel lawyer. What can I do, my lord? The documents are marked, it is produced before.
Where
the
is
court.
V. Prasanna Kumar? He is the panel lawyer.
The panel lawyer.
But how did the documents vanish from DRT?
It did not vanish. It was
ಮತ್ತೆ?
reconstructed and the counsel for the
No, no, one
complainant, my lord,
HCGP
he also says
Two
has been
emergent notice.
reconstructed to his satisfaction.
One HCGP panel lawyer ಏನ್ ಮಾಡ್ತಾರೆ?
No, but there are serious allegations, my lord. The
Against
documents
him
are-
also.
Against him also.
Ah.
Oh, no, there are no allegations against me, my lord,
Get the
except for the
investigation
fact that.
papers.
And
The
my lord,
learned
in-
HCGP is directed to, sorry, learned additional SPP is directed to accept notice for the first respondent. Emergent notice to the second respondent, list on 21st. The additional SPP is directed to secure the records of investigation and place it before the court on the next date.
my lord, in so far as accused number 2 and accused number 8, there is an interim order passed by this honorable.
Accused
court.
number 8, that
The
Gauramma,
presiding officer.
that Gauramma I have
And as
granted.
far as the managing director of SBI, my lord, there is an interim order of stay.
See, absolutely. So chairman and managing sitting in Bombay, what they will do, sir?
I'm just placing those.
I
facts
know that.
before
I
the
have
court.
granted those stays
Yes,
and
yes,
I am
yes.
aware of it.
My lord, and as far as the advocate is concerned, my lord,
Will
what
see.
role does he have to
No,
play,
he
my lord?
says their allegations. We'll see the papers and then grant.
Yes, my lord.
It's list on 21st in the fresh matters list.
My lord, till then, no coercive action be taken against.
Bail ತಗೊಳ್ಳಿ,
Bail. He's
bail
not-
ತಗೊಳ್ಳಿ.
It's a lawyer panel.
ಯಾಕೆ
advocate, my
bail
lord.
ತಗೋಬಾರ್ದಾ?
ಅಲ್ಲ, ತಗೋಬೋದು,
ಮತ್ತೆ?
but my lord, it would only lead to
No, no.
embarrassment to the lawyer.
That we'll see. If there's any problem, you move the matter. Yes. ಇದು ಅದಕ್ಕೆ PCP NDT. Shamsundar.
93, please, my lords, for the petitioner, my lords.
The petitioner
Covered
is
by your
before-
lordships. Please,
covered,
please.
ಸರಿ 498 376 ಹೆಂಗಾಗುತ್ತೆ?
ಅವ್ರು ಮದ್ವೆ ಆಗಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅಡ್ಮಿಟ್ ಮಾಡ್ತಾರೆ 498 ಗೆ ರಿಜಿಸ್ಟರ್ ಆಗುತ್ತೆ.
The complainant registers a complaint for offence punishable under section 498A. The learned, the concerned court takes cognizance for offence under section 376 and 420 of the IPC. The two would not go hand in hand except in exceptional cases. Therefore, there shall be an interim order of stay of further proceedings square the petitioner till the next date of hearing. Yes, next.
Grateful.
94,
I appear for the petitioners.
Why, sir, you're not appearing still?
No, no. I was preparing for a afternoon, my lord, further hearing matter.
ಅಲ್ಲ ಇಷ್ಟು ದಿನ ಬೇಕಾಯ್ತಾ?
ಇಲ್ಲ further hearing ನಾಳೆ ಈಗ ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಅದಕ್ಕೋಸ್ಕರ I was preparing.
ಆಯ್ತಾಯ್ತು. Okay, okay. Yes. ಇದು 13th, sir.
Please, my lord.
13th.
Actual salary itself not.
That's all right. 13th.
Please.
Yes. Not to file charge sheet on the order ಮಾಡಿದ್ದೀನಿ. ಅದ್ ಮಾಡಿ list on 13th.
Please, even 96 also.
13 PC Act. 10th, yes.
Even 96 also not is the same.
ಆಯ್ತು, ಅರ್ಜೆಂಟಾ?
ಇಲ್ಲ.
95,
CC 2013.
My lord, that is why Annexure E might be looked into. My lord, it
E-
has been dropped according to the,
Who has
yes, all, my lord, about this. This is the statement made by the Home Minister, my lord.
Home Minister?
Please, my lord. My lord, this is with regard to this Kaveri River dispute. My lord, multiple cases.
Kaveri dispute.
My lord, Annexure E. my
One
lord,
72
73.
emergent notice. In the meantime, we will dispose it next time.
Please,
List on 21st. Next.
my lord, stay, my lord.
No, in the meantime, stay. Yes, next.
96,
Same, 10th,
Yes.
same order.
Yes.
Next.
BP Patil not I.
Same, ಅದು ಮಾಡಿ. Baby Patil take notice. ಎಲ್ಲ ಮಾಡಿ.
Please.
97,
1991 KP Act.
about
Get the papers, then gambling.
about the identical matter, your lordship.
Give
has
it, we'll
already
see.
stated.
Both
This is
will.
the case where the petitioner, who's an employee of a company, has been arraigned as an accused without the company itself being made a party.
KP Act ಅಲ್ಲ. We'll see. Patrolling. Tag this petition along with so and so. Same, copy the interim order. List on 20th. The fresh matters list. Learned additionally, the HCGP is directed to accept notice. Next.
98,
This case, the complaint is that amount of 2.5.
Have you reimbursed 250,000?
It has been
Where is
reversed.
that?
That is reversed. Your lordships will find it at page 156. Page 156, the last entry.
Why did you debit?
What had happened was the other company was a sister concern, and that account was going to become SMA, and therefore we debited the account of Chalo Fly, and it went to
Unauthorized debit.
that is what they say. But such a transaction has happened earlier.
Petitioner is before this court calling in question so and so. The issue in the list is with regard to unauthorized debit from the current account of the complainant. The complainant has also registered a case before the consumer forum on the same score. The complaint is registered. We are suppressing the fact that the amount of 250,000 was immediately reimbursed to the account of the petitioner. Therefore, there shall be an interim order of stay of further proceedings square the petitioner till the next date of hearing. Yes.
What had happened was 5th of May was the FIR registration. 16th May we have reversed it.
All right.
And great
99,
petition.
In the meantime,
100,
next.
So 1 and 3 ಗೆ stay ಇದೆ.
With 1 and 3 ಕೊಡಿ. Tag this and so and so.
It's annexed in the petition,
Page.
page number 59.
Page?
59.
Same order, madam. Next.
What's-
Same order, sir. ಅದ್ರಲ್ಲಿ stay ಇಲ್ವಾ?
That's stay.
Yes. A3 ಏನ್ ರೋಲ್ madam?
Pending before me.
No, we'll see. Learned counsel to BB Patil is directed to accept notice for the respondent. List on 13th.
Until then, not
to file
charge sheet, my lords.
ಅದು ಆ order ಇದೆ. Not to file charge sheet order ಇದೆ. Yes. In all these cases. Yes. Next. Madam, 18.
For petitioner, Your Honor. Your Honor, in this case, we are seeking direction to the lower court.
True, it's a 2023 matter.
No, Your Honor, this DV Act was filed in the year 2019 and it was transferred and now
It's
it is
become, okay.
referred as.
The petitioner is before this court seeking the following prayer, heard so and so. The learned counsel for the petitioner submits that a petition has been pending before the concerned court for the last 5 years. As the proceedings were instituted by the wife in the year 2019 and is transferred to the present court in the year 2023. Until now, there is no progress in the said case. All the members of the family are roped into the proceeding as respondents. In that light, I deem it appropriate to direct the concerned court to conclude the proceedings within 6 months.
Yes.
Within 6 months from the date of receipt of the copy of the order, if not earlier. It is needless to observe that the parties to the list would cooperate for disposal of the case as observed herein above. And in the event of non-cooperation, the concerned court would be at liberty to pass appropriate orders in accordance with law. Yes, next.
The senior counsel is on VC.
103.
Yes, sir.
Well, I am appealing for the petition.
Yes, sir.
But the issue has a checkered career.
Hmm.
Well, a number of writ petitions, writ appeal, and then a special leave petition also. Probably it would be useful for me to invite my lord's kind attention to the order which came to be passed by the division bench of this honorable court, which my lord gets at the ink page 207. All these writ petitions, my lord, and in the writ appeal, special leave petition, this is the subject matter. May I request your lordship to kindly have a cursory look at paragraph 44. Would your lordship permit me to take your lordship to this paragraph?
Yes.
In this regard, we also note that successive attempts made by the appellant to somehow stall the acquisition process has resulted in the respondent number 5 society and its allottees not being able to carry on any development in the land in question, although they have been already allotted. Further, on account of the successive litigation and stay orders granted by this court, there has been a delay in release of the plan, although relinquishment of the land for the purpose of roads and civic communities has been made by the respondent number 5 society in favor of the Bangalore Development Authority. We therefore deprecate the tendency of the appellant who has filed successive petitions before this court, which has taken precious time, and that too on the same pleas or on pleas which were available even when the earlier petition was filed. Further, other pleas which are not available to the appellant have been raised, where no relief could be given to the said pleas. In the circumstances, we dismiss the appeal with cost of rupees 1 lakh, the said cost, etc. Well, in the next writ petition, may I just request your lordship to kindly turn to my lord, page 200, and Supreme Court would dismiss it at page 200. Very next page, my lord, he would take up the matter before the Supreme Court, and the Honorable Supreme Court would also dismiss the special leave petition, page 209. Now, kindly go to page 227, WP number 7304, my lord. That would be very, very important. But I would move this honorable court for initiation of contempt proceedings against the BDA.
Yes.
Well, this on in that contempt petition, my lord, the BDA would give an undertaking before this honorable court that they are going to 227. Have a look at 227. Kindly go to the operative portion of the order, which my lord gets at page.
Now, who is the complainant?
Well, at complainant now, he would issue a notice to me to appear. Then I would file a writ petition before this court. Well, at that writ petition, your lordship would get at page 244.
244.
Well, the writ petition commences at page 227. Well, an interim order came to be passed by this honorable court at page 244. He would issue me a notice requiring my appearance before him. I would contend before him that who are you? You are not an officer in charge of a police station. You are an inspector of police attached to a squad in Bangalore Development Authority. You have neither an authority or a jurisdiction under the provisions of the code or under any other statute requiring my presence before you.
We'll tag it with this and post it tomorrow.
Please.
Heard the learned senior counsel Sri V. Nagesh appearing for the petitioner. Tag the petition along with page 244. List them both tomorrow in the fresh matters.
My lord, one more petition is there.
Number kodi sir.
Yes, my lord, in relation to this very matter itself, there is another complaint filed earlier to this.
Number kodi sir.
My lord, that is a criminal petition. Your lordship would get page 541.
ಅದ್ರಲ್ಲಿ ಇರೋದು
541.
ಸೇರಿಸ್ಬಿಡಿ. Yes, so it's next.
Obliged.
104.
Satyanand.
Lord, kindly see annexure yes 208. The petitioner, my lord, he is one of the trustees of this particular trust. My lord,
We'll see. One HCGP 2 emergent notice returnable by 21st. Till the appearance of the complainant, there shall be an interim order of stay of further proceedings. Next.
105.
Offenses under the Drugs and Cosmetics
Sanitizer.
Act. Please, no.
Sanitizer.
Sanitizer, lots. He held license for both the products.
here's the records.
ಇಲ್ಲ, ಆಮೇಲೆ the competent authorities declared that ethyl alcohol can be used.
Yes.
Here's the entire record.
And you have say that because of usage of ethyl alcohol, the sanitizer is withdrawn.
Yes.
Replace, sir.
It is of not of standard quality, my lord.
Because ethyl alcohol was there. Yes,
Now they are on bail, my lord, and split with bail.
yes, we'll see. One HCGP, who's the complainant?
There's only so he, they are this.
One HCGP list on 19th till such time further proceedings before the concerned court shall remain stayed on the score that what was alleged against the petitioner was usage of ethyl alcohol in the sanitizer, and for that reason it was depicted to be not of standard quality. The competent authority later approves usage of ethyl alcohol in place of isopropyl alcohol, and therefore the offense that was alleged against the petitioner becomes bleak.
Petitioners.
Petitioners
Great.
would become bleak. Yes, next.
Great.
6.
566 E, my lord. None of the ingredients as required. Made out. The complaint.
What made out?
My lord, if your lordship just gets the complaint, my lord. My lord, her allegation is that I have put up a post about this
Why?
complaint.
Instagram, why did you put up a post?
Lord, about 6.5 lakhs is
And
owed.
you know, Mystic, what is that? Mystic Substance account. Why did you create that?
That is the original Instagram handle of the petitioner here in, my lord. That is
Then
the
you
only-
mishandled it.
Lord,
Why?
If your lordship just gets the last page, my
I know,
lord.
I've seen it, no problem. It may not meet.
Yes, my lord.
Yes, sir.
Here's the investigation paper.
Kudi ತೊಂದ್ರೆ
ಕೊಡ್ತೀನಿ ನಾನು.
ಬಿಡಿ. ಇದ್ರಲ್ಲಿ ಏನಿದೆ?
Lord, private area by itself, by the act. That means.
Petitioner is before this court, so and so. The offense alleged against the petitioner is under section 66C of the Information Technology Act. The perusal at the complaint would indicate that it is, would demonstrate that the complainant herself is not sure as to what has happened. Therefore, there shall be an interim order of stay till the learned HCGP would secure and place the investigation papers on record. Yes, next.
Grateful.
107.
ರಿಟೈರ್ ಆಗಿದ್ದೀರಾ ನಿಜ, ಬಟ್ ಆಗ್ಬಾರ್ದು ಅಂತಿಲ್ಲ. 13(1)D.
Lord's disproportionate assets, they have included all those assets which is belonging to the wife, son and the father-in-law, which is acquired by them by declaring them, Lords, at some point of time in their income tax returns, having independent source of title.
ನೋಡೋಣ, there are identical matters on 13.
Yes.
On 10th, madam, 13.
13th, Lords, I'm told.
We'll take this also. ಅದರಲ್ಲೂ ರಿಟೈರ್ಡ್ 4 ಜನ ಇದ್ದಾರೆ.
Retired, Lords, more than the retired here, Lords, it is the whole problem is whether it is either mischievous or otherwise, if it is reflected from the records which they have themselves seized.
This is what we have to lay down, sir, because they have declared in their APR. Then, sorry, APR, that.
Income tax and
annual-
ITRs.
ITRs ಹೌದು.
Yes.
Then annual assets and liability statement.
There also it is declared.
ಅದಕ್ಕೆ ಅಲ್ಲೆಲ್ಲ ಮಾಡಿದ್ಮೇಲೆ.
Where is any question of that's the reason? Please.
ಅದ್ರ 4 ಇದೆ ಆನ್ಸರ್ ಮಾಡಿ.
Please.
ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರ?
ಇಲ್ಲ ಹಾಕಿಲ್ಲ.
Not to file charge sheet.
Please.
Heard the learned senior counsel sounds. Yes.
Great.
Based on 13. Settlement talks ನಡಿಬೇಕಾದ್ರೆ ಯಾಕೆ ಕ್ರೈಮ್?
That's,
ಹಾ
that's my recall.
ಸೆಟಲ್ ಮಾಡ್ಕೊಂತ ಇದ್ದೀರಾ ಮಾಡಿ.
ಅದು ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ಏನಕ್ಕಿದು?
No, no, this is a issue, my lords. May I just pass this one sheet?
ಇದು ಕೊಡಿ.
One
Yes.
minute. Just to see what is happening, because my lords had started with a question, my lords. I just want to answer it. I don't want to read it, my lords. On Sati note.
U-turn ಆಗಿ ಹೋಗಿದ್ಯಾ?
Huh?
U-turn.
U-turn kinta.
Failure.
See,
Yes.
my lords.
All right, you serve on the council.
No, there's no party on the other side. It is only a direction which I'm seeking, my lord.
What
My turn.
direction?
Yes, my lords. My lords, my turn to.
Complete the investigation.
Yes.
ಅಲ್ಲಿ settlement talks ನಡೀತಾ ಇದೆ, complete the investigation. We'll see.
No, settlement talks failed, but the answer also.
Number ಕೊಡಿ ಅದು. Those numbers ಕೊಡಿ.
That's,
Those writ petition numbers.
yes, my lords, I'll give that.
Give it. Tag along with that.
That's that, but just 1 second. That matter, my lords, is pertaining to perjury, my lords. In so far as this is concerned.
Sir, between the husband and whatever, there are talks going on, or it has failed, we don't know. I have adjourned that matter on the ground that talks are on. ಹೌದಾ?
No, talks on ಅಲ್ಲ.
ಮತ್ತೆ?
ಅದು fail ಆಗಿದೆ, final hearing ಅಂತ 4ನೇ ತಾರೀಕು ಹೋಗಿದೆ. It's gone to.
4ನೇ ತಾರೀಕಿಗೆ ಹಾಕೋಣ. List on
This
4th.
has got nothing to do with them because it's only the state government. My lords, may
It's
look
all
at-
right, sir. Investigation ಅವ್ರ ಮೇಲೆ ತಾನೇ ಮಾಡ್ಬೇಕಾಗಿರೋದು.
That's my only
Sir,
request.
you can't blow hot and cold. Sit on the settlement table and arm twist them with this. It's not.
No, my lords, settlement talks have failed.
ಆಯ್ತು, 4th will take it. List on 4th.
Please.
My lord, my instruction, my lord, in the present crime, my lord.
Charge sheet ಹಾಕಿದ್ದೀರಾ?
B report ಆಗಿದೆ.
B report. Question ಮಾಡಿ B report.
Yeah, they have not even called us.
We'll close it.
Lords, in that case, my lords, let this matter be had next Monday or Tuesday.
All right,
Lords, I'll just-
list on 10th. ಅದು produce the B report. You'll register another crime ಆಮೇಲೆ.
Lords, but the fact of the matter, my lords, the settlement talks between the two of them have failed. And my lords, the answer was appearing for the respondent there. And my lords, we made a submission. My lords, post that, my lords have posted it for hearing on the merit of the case. That's for day after. So this matter, my lords, and that matter are two different things.
All right. B report ಆಗಿದೆಯಾ ಅಂತ ತೊಂದ್ರೆ ಇಲ್ಲ.
Let me just check that, my lords. My lords may have it on 10th. Let me. have it.
10th in the fresh matters list. Learned HCGP on instructions would submit that the police after investigation have filed a B report.
Yes, sir. See.
Order 109.
Filing memo for withdrawal.
In terms of the memo.
110 withdrawal memo ಇದೆ.
In terms of memo.
One 111.
Hitesh Road. No representation, list after 2 weeks. ಏನಿದು? Why moved? Swami.
My lord, it's all these 4 petitioners, please, my lord, they are arraigned as accused number 1 to 4 for the offences under 306 of the IPC. The deceased is the husband of accused number 4, please.
Charge sheet ಆಗಿದೆಯಾ?
Agide, charge sheet has been filed, please, my lord. That, my lord, on the previous day, please, my lord.
1 minute, 1 minute. List day after tomorrow in the fresh matters list.
Please, my lord.
Yes, next. Question?
113.
Time ಬೇಕಾ? You want time?
No, my lords. My
Which is the earlier matter?
My lords, I had, during the crime stage, I had filed, my lords. Criminal petition.
ಇದು 306.
Please, my lords. Only on the basis of the voluntary statement, my lords, which they have forcibly made.
Well,
clear.
same day after tomorrow in the fresh matters list. Yes, next. Rohan.
114.
Complaint emerging 153, not 153A, 295 and 505 in respect of a tweet that's deleted 2 hours after it's posted. Complaint, your lordship will find it page 28.
Yes, government.
2 hours after I delete the tweet with an apology.
Tomorrow in the fresh matters list.
Very.
Yes. Settlement.
14 settlement, 115.
Your lordship. I have a petitioner 498, your lordship. Matter reporting settlement.
Where?
What is the present? Please go to that.
Good.
Because, come this way, both.
ಎಲ್ಲಿದೆ settlement?
My reporting H is there. Joint also, my memo also filed.
NVJ, application compounding, a joint affidavit ಮಾತ್ರ quote ಮಾಡಿ. Yes. Next.
Order sheets. 116.
Yes, Latif.
Settlement, it may be on next Monday, my lord.
All right. We have date. When do you want?
Next
When-
week, any date. my lord.
All right, yes, next.
Date may be fixed.
Next, 10th, 10th at 2:30 PM.
Please.
Report settlement. Next, 117.
117.
ರೂಪ. ಯಾಕೆ ಆಗ್ಲಿಲ್ವಾ? ಅದ್ಯಾವ್ದು ಇನ್ನೊಂದು ಪೆಟಿಷನ್ ಅಂದ್ರಲ್ಲ?
ಒಟ್ಟಿಗೆ ಸೆಕೆಂಡ್ ಪೆಟಿಷನ್ ಅಲ್ಲಿ ಸೀರಿಯಸ್ ಅಂತ ಹೆಲ್ತ್ ಇಶ್ಯೂಸ್ ಅಂತ
ಆಯ್ತು ಸರಿ. List tomorrow at 2:30 PM. 2:30 ಬೇಡ, ಲಿಸ್ಟ್ tomorrow ಹಾಕಿರ್ತೀನಿ, ನೀವು ಯಾವಾಗ ಬಂದು ಬನ್ನಿ. Yes. Next.
118.
This first time ಕಾಮನ್ ಆರ್ಡರ್ ಮಾಡ್ಬಿಡಿ. ಇಲ್ವಲ್ಲ ಯಾರು? 10th ಹಾಕಿ. ಇದರಲ್ಲಿ ಏನಾದರೂ ವಿಡ್ರಾಲ್ಸ್ ಇದೆಯಾ?
Non-compliance of office objections.
For the first time.
119 to
2
203.
weeks time granted. ಯಾವ್ದು withdrawal ಯಾವ್ದಿದೆ ಎಲ್ಲ ಕೊಡಿ. 2 weeks time is granted to comply with
My
the
lord.
office subject. 1 minute.
My lords, one submission,
1 minute.
201, my lords.
1 minute. 2 weeks time is granted to comply with the office objections. In the event office objections as on today have been complied with, the registry shall list the matter on the 9th without a memo being moved before this court. In all the cases where office objections are still pending today, in the event they stand complied, the registry shall list the matter on 16th Monday without a memo being moved before this court.
My lord,
17th, yes.
Serial number 149 is concerned, my lord. I'll comply the office objection on 18/11.
ಅದನ್ನೇ ಹೇಳಿದ್ದು. If it is complied, it will come on Monday.
It is covered by matter, my lord.
No problem. If it is complied, it will come on Monday. ಅವತ್ತೇ ಕೊಡಿ. Yes.
My lords, one submission, my lords.
129 withdrawal.
ಆಯ್ತು, ಅದ್ರ ಮಧ್ಯದಲ್ಲಿ ಯಾವ್ಯಾವ್ದು ವಿಡ್ರಾವಲ್ ಇದೆ ಅದು ಕೊಟ್ಬಿಡಿ. ಎಸ್.
Number 197 withdrawal.
197. 1 minute. ಅದು ಫಸ್ಟ್ ಟೈಮಾ ಸೆಕೆಂಡ್ ಟೈಮಾ?
Fine.
First time, all right. 197 on submission, land council with the petitioners of 6 leave of this court to withdraw the petition. Submission is placed on record, disposed as withdrawn. Yes, next.
Serial number 147, my
My
lord.
lords, serial number 201.
147.
147.
147. My
ಏನು?
lordship, this matter is connected with the criminal petition number 8951 of 2022 in this case. Your Honor.
ಆಯ್ತು, tag this petition along with
I am filing in a memo with respect.
ಬರ್ದು ಕೊಡಿ ಅದು.
Filing in a memo.
ಕೊಡಿ, ಎಸ್. ನೆಕ್ಸ್ಟ್ 207 ಏನು?
201, my lords.
201 what?
201, my lords, there is no need to comply the office objections as the matter is already been settled, my lords. And another one more petition is there, my lords. Criminal
Number-
petition
number
60,
ಕೊಡಿ.
66 of 2024.
Number ಕೊಡಿ.
60, 66 of 2024. 2022. Sorry, my lords, 60, 66 of 2022.
ವಿಡಿಯೋ ಆಫ್ ಆಗಿದೆಯಾ?
Video off ಆಗಿದೆ ಸುಮ್ಮನೆ.
Yes, so and so. Let's tag this petition along with so and so. Same order, ಮಿಕ್ಕಿದ್ದು office objection, same order.
ಅಲ್ಲ, ನಾನು ಅಲ್ಲಿ ಬಂದು ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ ನಂಬರ್.
ನಂಬರ್ ಕೊಡಿ,
ಆಯ್ತು.
ಹೇಳಿ.
ಮಂಡೇಗ್ ಹಾಕಿದ್ರೆ ಒಳ್ಳೇದಾಗುತ್ತೆ ಸ್ವಾಮಿ. ಈಸ್
ನಮ್ಮ-
ವರ್ಕಿಂಗ್ ಇನ್ ಹೈದರಾಬಾದ್, ಸೊ
ಸರಿ
yeah,
ಬಿಡಿ.
all the way has to
Monday ಬಂದು
ಏನೋ
ಕೊಡ್ತಾರೆ.
ಬರ್ತಿದಾರಂತೆ.
Yes. ಆಯ್ತು. ಮಂಡೇ ಬಂದು ನಂಬರ್ ಕೊಡಿ.
ಈಗ್ಲೇ ಬಂದು ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ.
ಕೊಡಿ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ, ಕೊಡಿ. ನಂಬರ್ ಕೊಡಿ.
ಆಯ್ತು, ಮಂಡೇಗೆ ಡೇಟ್ ಕೊಟ್ರೆ so that they will come on Monday, my lords.
ಆಯ್ತು. Come on Monday. List on Monday.
Please, my
Yes, next.
Serial number 214, my lord. 214, my lord. Withdraw the case.
214. in submission withdrawal. ಆಮೇಲೆ 210 ಅದೆಲ್ಲ NVJ ಕೊಟ್ಬಿಡಿ. Second time,
To 233.
10 days time, same order.
214
Serial number 229. The objections, the rest of the objections we have complied.
No problem. Whatever. I have passed an order. If you have complied, Monday.
Other three objections.
Madi.
Name of the petitioner number not forthcoming in the FIR.
Madi.
So that is not mentioned in the FIR.
That will see. Whatever I have granted, if you comply with the objections, Monday it will come. Yes, next.
Third time matters 234 to 275.
Ado same 10 days peremptory order. In the event they stand uncomplied, the petition should be dismissed for its non-prosecution. Yes, fourth time.
Time 276 to 281.
Fourth time.
ಏನು ಅಂತ ಗೊತ್ತಿಲ್ಲ ನೋಡಬೇಕು.
ನೀವು ಹೋದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ ಏನು ಅಂತ. Yes. 1 week time is granted, failing which dismissed without reference to bench.
282 by lot.
Sixth time. 1 week time finally, same, dismissed for non-prosecution in the event they don't comply. Yes.
230.
230? Yen sir? Yen beku?
Serial number 230.
230 na?
230.
213.
203.
230. Yen ಆಗ್ಬೇಕು?
Senior ಬರ್ತಾ ಇದ್ದಾರೆ.
Senior ಬರ್ಬೇಕು.
ಅದು ಟೈಮ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ.
Senior
2 ವಾರ. ಸೀನಿಯರ್ ಬಂದ್ರು ಅದೇ ಆಗೋದು.
petitioner.
ಸೀನಿಯರ್ ಬಂದ್ರು ಆಮೇಲೆ ಎಂಟ್ರಿ ಮಾಡಿ ಯಾವ್ದೆಲ್ಲ ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಯಾವ್ದಿಲ್ಲ. ಸರಿ, ಎಸ್.
Serial number 111, my lord. It actually challenge the transfer of the petitioner from Bangalore Central Prison to Belagavi, my lord. Serial number 111, my lord.
Transfer?
Please, my lord. He's been transferred from Bangalore Central Prison to Belagavi Central Prison, my lord.
ಯಾವುದು ದರ್ಶನ್?
The actor Darshan.
ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ?
Please, my lord. I have challenged only with regard to accused number 14 in this matter.
ಓಯ್ ನೀವಿಲ್ಲೇ ಇರ್ಬೇಕಾ?
Please, my lord. I have my sufficient reasons to convince this court.
Then tomorrow in the fresh matters list. 111 tomorrow in the fresh matters list. ಯಾಕೆ? He's not yet transferred.
It's already been transferred. It's
Already been transferred.
Yes, my lord.
Repatriate ಮಾಡಬೇಕು ಅಂದ್ರೆ ಸ್ವಲ್ಪ ಟೈಮ್, 1 ವಾರ ಕೊಡೋಣ.
A date may be fixed.
List on 111 ಮಾತ್ರ. List on next 10th, 11th. List on 11th in the fresh matters list.
Please.
Darshan also wants to come back, huh?
No, my lord. This is only with regard to accused number 14 because he has no role to do with regard to the transfer, my lord. Because the Parapanagrara PS has registered an FIR also naming other accused persons, not with this particular accused, my lord. The lapse of the state government has.
All right. 230 ಅದು ತಗೊಂಡಿದ್ದೀವಿ. ತಗೊಂಡಿದ್ದೀವಿ. 280 ಇಲ್ಲ ಬಂದೇನಾ?
ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಬಲ್ಲ ಮೇಡಮ್. 214 ಮೇಡಮ್ ಆ ಮೆಮೊ ಕೊಡ್ಬೇಕು.
Now, only matter left.
Yes.
So you have to start.
Very good. Not having heard my learned friend, my lord, appearing
Now,
on-
Senior Counsel Maninder Singh has submitted.
Yes,
He was appearing for the fourth respondent.
yes,
He said something left which are in Kannada,
quite right.
you are going to submit.
Not only in Kannada, my lord, there are a few more points.
Other languages ಇದೆಯಾ?
ಇಲ್ಲ ಇದು ಎರಡೇ ಲ್ಯಾಂಗ್ವೇಜ್ ಕನ್ನಡ ಅಂಡ್ ಇಂಗ್ಲಿಷ್
Only Kannada
ಇಲ್ಲ
ಅಲ್ಲ.
ಇನ್ಯಾವ ಲ್ಯಾಂಗ್ವೇಜ್ ನನಗೂ ಆಗ್ತಾ ಇರ್ಲಿಲ್ಲ.
Not only in Kannada, ಅದು ಬೇರೆ ಯಾವ್ದ್ರಲ್ಲಾರು ಇದೆಯಾ?
ಇಲ್ಲ ಇಲ್ಲ ಇಂಗ್ಲಿಷ್ ಅಷ್ಟೇ,
ಆಯ್ತು.
ಕನ್ನಡ ಅಂಡ್ ಇಂಗ್ಲಿಷ್.
ಆಯ್ತು. Huh? Oh, polyglot. Yes. Yes, sir.
ಇಲ್ಲ ತಮ್ಮ ಮುಂದೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋಷ್ಟು ಕೆಪಾಸಿಟಿ.
Yes, sir. Yes.
Lord, having heard my learned friend Mr. Singhvi, my lord, appearing on behalf of the petitioners, I would put his submissions, my lord, in three silos. One on law, second, my lord, on facts, the third, my lord, rhetoric with some sarcasm. Insofar as the third is concerned, my lord, I don't think I need to spend my time.
What is the third?
Rhetoric with sarcasm.
Sarcasm.
Yes. And so far the third is concerned, my lord,
All right.
I will not detain your lordships because I do not think it is appropriate for us to do that. Though, my lord, I can
Lot
reply
of
to that.
rhetoric has happened.
My lord,
Lot of rhetoric has
that's what I'm saying, my lord. A lot of rhetoric has happened, though I can reply to it, my lord, in the same manner, but I will not.
No,
waste it
it's
all
all
time. Now, my lord, coming to I would first address your lordships on the question of law, my lord, which I want to place before your lordships a slightly different perspective, so that, my lord, your lordships will define the contours of interference in a judicial review proceeding with respect to an action purportedly taken under section 17A. Kindly now see section 17A for a minute, my lord, in the perspective in which I want to place it before your lordship. I know it has been read to your lordships ad nauseum, but let me place it in the manner in which
Yes.
I would like your lordships to kindly read.
Yes.
No police officer shall conduct any inquiry or investigation into any offense alleged to have been committed by a public servant under this act, where the alleged offense is relatable. Your lordships may mark that word, my lord. There is something that turns on this word. Where the alleged offense is relatable to any recommendation made or decision taken by such public servant in the discharge of his official functions or duties without prior approval. So, my lord, this section does not contemplate even an application. Please contrast this with section 19, my lord.
So sanction operates on a different footing.
No, there, my lord, under 19, it contemplates a request.
Yes.
17A doesn't even contemplate a request.
It's all right. We'll see.
No, my lord, what was told to your lordship was that it is only the police officer who can go and seek
So
for.
that, if you see, that I straight away dispelled.
Yes.
So that no police officer can begin investigation unless there is an approval. That doesn't mean police officer only should seek approval.
Exactly.
That I
And
already
in fact,
said.
my lord, the question of seeking approval itself is not contemplated under 17A. It is permissible that the authority acts on information which is available in public domain or otherwise without even a request being made. This becomes material, my lord, in the context of the serious submission that was made before your lordship, that a copy of the petition that had been submitted by respondent number 4 was not furnished to the petitioner, and that is a grave infringement of the mandatory requirement of 17A.
If the foundation itself does not require,
Exactly.
why would a superstructure require?
Exactly. Lord. That's what I wanted to point out, your lord.
All right, next.
Therefore, that's first subject. Then, my lord, the second question would arise in the context of 17A. Should the recommendation be made or a decision to be taken by a public servant? It is to be relatable to.
No, in this case, relatable.
Yes.
is quite debatable. We'll see.
Exactly,
Yes.
my lord. Relatable is debatable, my lord. I bow down. That is why an inquiry.
Yes.
My lord, if it was.
That is why an inquiry will see.
that's my submission, my lord.
Relatable is debatable.
Relatable is debate. That's right, my lord. I mean, at the stage of 17A, application of mind, there is no material which is available which can point in one or the other direction. It is a matter where suspicion, needle of suspicion,
No, needle of suspicion pointing at a particular act of a particular person.
Quite right.
See, needle of suspicion also cannot be in thin air. So there should be something. And he has threadbare told what is there. We'll see whether it is relatable or not.
Quite right. Now, my lord, another important aspect that I want to bring to your lordship notice is relatable. No police officer shall conduct any inquiry or investigation into an offence alleged to have been committed by a public servant under this act. Now, what are the offences under the provisions of the PCA Act? My lord, kindly see section 7. My lord, there's something that turns on section 7, my lord, which I want
Criminal
to point.
misconduct by a public servant.
No, my lord, there's
So this
something
is
more. There's something more. I want your lordship to be kind enough to see section 7.
Yes.
Any public servant who,
The offense relating to public servant.
yes, quite, no, my lord,
No, see, 7 is offense relating to public servant being bribed.
no, my lord, kindly see C.
The 7C is 7C.
7C.
7C is the only thing that is something there.
Exactly, my lord. 7C, your lordship will kindly see, performs and, no, my lord, more importantly is the explanation 1 and explanation 2 to section 7. Performs or induces another public servant to perform improperly or dishonestly a public duty or to forbear performance of such duty in anticipation of, in consequence of accepting an undue advantage from any person. Now, my lord, this is explained by explanation number 1. For the purpose of this section, the obtaining, accepting, or the attempting to obtain an undue advantage shall itself constitute an offense, even if the performance of a public duty by a public servant is not or has not been improper. So, my lord, I ask myself the question, suppose, my lord, in a given case, what has been done is legal. But that legal act has been induced by a public servant.
No, then it does not become an offense.
But then, my lord, I ask myself, what was explanation 1?
legal
Then
act-
kindly see explanation 1.
No, don't, not the self-golagman.
No, my lord, kindly, no, not in this case. Kindly see explanation 1. Otherwise, explanation 1 will have no meaning. Because for the purpose of this section, obtaining, accepting, or attempting to obtain an undue advantage shall itself constitute an offense, even if the performance of a public duty by a public servant is not, or has not been improper. So let us assume, my lord, in a given case that it is not improper. I'm not in this case, my lord. I'm saying, look at the width of the inquiry that is required to be made under section 17A. It is for that purpose, my lord, that I'm pointing out this. In this case, my lord, I'm going to show to your lordships a few more facts.
2 more facts are there?
Yes, my lord. Yes. I'm going to show to your lordships a few.
More than what he has told.
Yes, my lord. Yes, my lord. There is something more. And on the same facts that my learned friend has placed before your lordships, my lord, I want your lordships to look at it in a manner in which I would like to place it for your lordships.
Different angle.
Different angle, my lord. Therefore, my lord, that would throw some light, would move assistance to your lordships to see as to whether in this case there is something that requires to be investigated or the investigation to be scuttled without anything more. Because if the investigation is scuttled and the governor's order is set aside, there will be nothing more to be done in this case. Unless, my lord, it's a question of re-examination, rewriting that's a different matter. But
the submissions are otherwise. If you leave that also, everything subsists. Is what he is.
I will, your lordships may look at that also. I'm not saying no. I'm not saying no, my lord. But there are different ways of looking at the same
That's
issue.
why yours is a different angle.
Exactly, my lord. That's why, my lord, when a lawyer, my lord, wanted an adjournment in court on the ground, my lord, that he had forgotten his spectacles. That said, not necessary. Take my spectacles. I'm not going to grant you an adjournment. And the lawyer, my lord, used the judge's spectacles and still said, I want your on an adjournment. He said, why? I'm looking at a case from your point of view. I want to look at it from my point of view. So, my lord, the way, my lord, one learned counsel looks at it, the way your lordship looks at it, the way I look at it are all different. Therefore, my lord, I want to place it from the point of view of how I would look at it. Now, my lord, I have to give a meaning to explanation 1. What is the purpose of saying even if the performance of a public duty by a public servant is not or has not been improper? Now, my lord, suppose, my lord, a legal thing is done in a given case, but it has been induced to be done by a public servant for the purpose of gaining an unfair advantage. Would that amount to an offense under the Act? My lord, explanation 1 seems to suggest that. Otherwise, my lord, these words shall itself constitute an offense even if the performance of a public duty is not or has not been improper. Therefore, my lord, it appears as if the philosophy of the Prevention of Corruption Act is do not use your public office to obtain an advantage.
Legal or illegal.
Exactly. All right. That seems to be the high pedestal of public morality, which, my lord, the Prevention of Corruption Act seeks to protect, my lord. Then, my lord, please look at explanation 2 in the same section, section 7. For the purposes of this section, the expressions obtains or accepts or attempts to obtain shall cover cases where a person being a public servant obtains or accepts or attempts to obtain any undue advantage for himself or for any other person by abusing his position as a public servant or by using his personal influence over another public servant or by any other corrupt or illegal means. So therefore, my lord, even if you have used your personal influence, not necessarily as the boss, not necessarily as the boss, even if you have used your personal influence, it comes within the mischief of section 7. My lord, in a given case, my lord, let's assume a public servant, a minister, my lord, is not in charge of the department. He has nothing, no role to play, but uses his personal influence. My lord, would it constitute a offense under section 7? Explanation 3, explanation 2 seems to suggest, yes, it is. The moment you hold a public office, it carries with it certain obligations and certain do's and don'ts, which are not attached to a non-public office. Therefore, my lord, even if you are not directly connected, but if you have used your personal influence over a particular matter in respect of which a decision has been taken and you are the beneficiary, that itself constitutes an offense under explanation 2 to section 7. Therefore, my lord, the contours of a offense in respect of which an inquiry is required to be held under section 17A are very wide. That's the point I'm trying to make for your lordship's consideration. My lord, it is not like a complaint which requires ingredients of the offense to be mentioned in the complaint, without which your lordships day in and day out interfere under 482 and quash it.
That's after registration of the crime.
My lord, it is after registration of the crime at the stage of investigation. Yes, but it could be, my lord, it never reached the court, excepting on FIR. Now, in a situation of that kind, even if there is, in the instant case, there are no allegations in the complaint, there's nothing. Still, if the sanctioning authority in the instant case being the Honorable Governor says, well, there is something that requires to be inquired into, not necessarily, my lord, as a list between A versus B, because the philosophy of 17A is different. The whole philosophy of the PCA Act is different. The philosophy, my lord, is to have a purity in public administration. That, my lord, is the paramount object of the Prevention of Corruption Act. If from that point of view, the sanctioning authority says, well, it is as important to be clean as it is to for the people to have confidence in a clean administration. Now, please look at it from that point of view, my lord. It's really not in the nature of a list between the petitioner and anybody else. It is in the interest of purity of public administration. If in that anxiety, if the sanctioning authority says, having regard to the high position that a person is holding, it is necessary that it should be inquired into, I ask myself, what is the scope of interference in a 226 judicial review proceedings? That, my lord, would be the approach I would suggest to your lordships to adopt in this case. It is really not a list between A versus B. there is an element of public interest, and if in that anxiety, the high functionary like the governor, and I will point out your lordship the judgment, my lord, which of course your lordships will be aware of it, that where a discretion is vested with a high functionary, the courts would be very reluctant to interfere with that order. My lord, your lordships are not going to look at, I would respectfully submit, with the order passed by the governor in under 17A, in the same manner in which your lordship will look at an order passed by the Tahsildar.
It was submitted.
My lord?
That was argued. I think.
Yes. So therefore, my lord, if it is so, and I'm going to show you some authorities on that. If that is the position, what is the extent to which this court can go into while examining the action of the governor acting under 17A being a constitutional functionary? So therefore, my lord, what I would submit to your lordship is, please look at it from the point of view, not as an adversarial litigation. When your lordships are looking at the sanction under 17A, do not look at it as an adversarial litigation. Please look at it from the point of view of ensuring not only there is purity in public administration, but that public confidence in administration is not sullied. If it is damaged, it is restored. What is the best way of restoring, my lord, an eroded public confidence in administration?
Where is it eroded?
Well, let me develop it, but I will show to your lordships that. What is the best? Because it is the very fact that a commission of inquiry has been constituted under the Commissions of Inquiry Act itself indicates that there is an anxiety to get this matter inquired into because it is a matter of public importance. And that has been referred to by the Honorable Governor in the order. If it was a matter in respect of which no inquiry was required to be done, I asked myself, why was the Commission of Inquiry required? Whole object of the Commission of Inquiry Act is that you will have this inquired into in accordance with the special statute. In order, my lord, your lordship knows, my lord, that the report of the
So
Commission.
you are satisfied with the Commission of Inquiry?
No, my lord.
What is your suggestion?
I tell you lordships why. Commission of Inquiry Act, unfortunately, my lord, a report of a Commission of Inquiry has no teeth.
We'll give it.
No, my lord, yeah, but the statute doesn't, my lord. The statute doesn't, my lord. In fact, there's a recommendation made by the Supreme Court saying that something must be done, nothing has been done. And the Supreme Court, my lord, has recognized that all these commissions of inquiry report are put in cold storage.
We will not permit.
But that is an independent and a parallel remedy. That is not necessarily a bar to a sanction under 17A. Therefore, my lord, this submission I made is in answer to the aspect, my lord, of eroding public confidence in public administration. How is it eroded? The very fact that you constitute a commission of inquiry indicates that there is something to be inquired into. Is it something that does not require, is a matter of public importance, is what the Commission of Inquiry Act
Then there is
says?
something being inquired into.
Yes.
So
Yes.
Why all this exercise?
My lord?
Why all this exercise?
Of course, my lord, there are two parallel remedies. Of course, there are two parallel remedies.
Don't emphasize on what is being inquired into.
No, that is only to answer the question, my lord, as to where is the erosion of public confidence. If there was no fear of erosion of public confidence in public administration, then the question of constituting a commission of inquiry would not arise. It is from that point of view I'm making the submission that the very fact that the government itself considers that there should be an inquiry into this matter and a matter of public importance itself indicates there is something that required to be inquired into. And all that is required under Section 17A is that there is something to be inquired into. And the entire allegations, my lord, are with respect to persons holding public office. Maybe, my lord, ultimately after inquiry, there will be a clean sheet. Maybe not be, I don't know. But why scuttle it at this stage? I mean, why not? Whatever is the truth. Maybe, my lord, there is truth in what is being alleged. Maybe there is truth in what is being said for the other side. We don't know at this point of time. Therefore, at this point of time, would your lordships want the cloud on the purity of public administration to remain? Is a question of this kind. the courts must lean in favor of getting matters inquired. Not
ನೀವು ಅಷ್ಟೊಂದು ಪಾಸ್ ಕೊಟ್ಬಿಟ್ರೆ ಮಧ್ಯದಲ್ಲಿ ಕಷ್ಟ ಆಗುತ್ತೆ.
ಅದು
Courts. Which side? Lighter way, yes.
ಅದೇನಾಗುತ್ತೆ ಅಂದ್ರೆ
In the lighter ways.
I know.
don't mind, yes.
No, I fully
Yes,
understand. I fully understand, my lord. We have seen your lordships and we have gauged, my lord, to the best of our ability
Yes.
as to what the court means when the court is asking a question. We know that. The one thing that we are never able to gauge, my lord, and rightly so, is what is the final decision.
Oh, if you gauge that, then what?
Exactly, we can't do that. ಅದು ಸ್ವಲ್ಪ ಕಷ್ಟ.
Yes.
ಅದು best is not to do it, my lord.
Yeah.
So now, my lord, coming back to the point, my respectful submission to your lordship is please lean in favor of getting matters inquired into. That consideration when your lordships are looking at 19 would be different, and we are not considering that
Correct, in a
today,
different
in a
way.
different. Now, my lord, having told your lordship that, my lord, I prepared a list of dates and factual aspects, and I want to take your lordship through a few factual aspects, which is relevant.
ರಂಗನಾಥ್ ರೆಡ್ಡಿ ನಿಮ್ದು ಲಿಸ್ಟ್ ಆಫ್ ಡೇಟ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ. ಪೂರ್ತಿ ಇಲ್ಲ. ಎಸ್.
Please note, my lord, just a few things, that between 1996 and 1999, I mean, this is not there in this. I would trouble your lordship to kindly just note these periods.
1996
to 1999, the petitioner was the deputy chief minister.
ಇದ್ರಲ್ಲಿ ಇದೆಯಾ ಅದು? ಇಲ್ಲ.
ಅದೊಂದು ಮಿಟ್ಟೋಗಿದೆ.
ಮೋಸ್ಟ್ ಇಂಪಾರ್ಟೆಂಟ್.
You know, written that, no?